As you know, each side will have 15 minutes, and the appellant may reserve up to 5 minutes for rebuttal if you wish. Please let me know if you wish to reserve any time, and I will give you a signal when you're encroaching on your time. Thank you. You may begin.
May it please the court, counsel, my name is Laura Mills, and I'm here on behalf of James Foy. I would like to reserve the 5 minutes, please, for purposes of a rebuttal.
And I'll give you a hand signal when you're almost there. So.
Wonderful, thank you, Your Honor.
Thank you.
This case has had such a long history, unfortunately, and there was substantial amounts of time in the trial court, which has necessitated, in addition to the legal issues we face here, kind of a messy CSEA, a rearage problem, recording problem, and so forth. Just as a brief history for the court, these parties began their divorce by filing in 2011. Actually, I believe filed in 2011. There was a hearing in 2012, and the parties had resolved all their issues except for support at that particular point in time, both spousal support and child support. There was one minor child at that juncture. It took the court about 10 months in order to actually finalize the divorce, and they did it in 2 stages. I was not the trial court counsel in this particular matter. I got involved sometime in September of 2013 because my client did not have a judgment entry, had not received his divorce. And at that particular point in time, what the trial court did, and I'm sure this court is aware, is they issued the judgment entry saying, fine, you have a divorce, and we're going to reserve and roll later on the child support and spousal support. Obviously, this court, and rightfully so, dismissed our appeal because we appealed that judgment entry in January 2014, went back to the trial court, I believe through counsel, Mr. McCarter and myself, we combined a non-protonc entry for the court in order to combine those 2 judgment entries to in fact have one. And then, unfortunately, that sat for another almost 10 months, 11 months before we received that particular judgment entry, just with the combined and consolidated entries, that being the grant of the divorce and 2, the ruling on the support. So here we are in 2015. My client has the just the messiest arrearage CSEA issue. There were modifications requested during this time. Quite honestly, it's one big mess. In looking at our first assignment of error, it's extremely important, obviously, that by the time the worksheet was done by the court, which was 2013, when initially this divorce started in 2011, actually latter part of 2013, the child support was determined without any alimony. Now, my client had paid temporary alimony, obviously, through the pendency of this case. Then there had been a trial in 2012 on what the alimony should be. And then in 2013, we get a ruling what the alimony, then the final alimony amount is supposed to be. There is no reflection in the child support worksheet in arriving at the child support. And I don't think, and I understand that counsel obviously disagrees with me, but I think the 9th District is pretty clear in the Zyman case that you have to account for that. It would be extremely unfair to have one spouse obviously paying another spouse and then getting hit for child support on the income that he has given away and not accounting for that. So Zyman, and I'm not going to take any time in front of the court to explain Zyman, it's very well set forth. It says it's a common sense approach. There was evidence in the trial transcript of the support that my client was paying. Clearly he was, had been through the temporary orders and beyond. The Wilkerson case was another case that we just cited, I think, in our reply brief. And just briefly, because Appley makes the argument that at the point in time the child support worksheet was done, he wasn't paying support, and they used the, I think it's the Albright case for that proposition. In that case, he hadn't paid any support. That's not true of this particular case. Wilkerson makes it clear. I think in that case, the parties went in for a modification maybe around April and May of the year, and the court still used the annual amount of alimony, even though the entire year had not been paid, when they calculated it. Otherwise, we'd be back in and forth to the domestic relations court. If you only used the amount of alimony that had been paid up to the point of modification, it would change every month. So you would constantly be going back in and saying, well, wait a minute, now we paid this much, so our child support would be that much. We take a look on an annual basis. It's what we do for our income. We don't put our income year to date. When we do the worksheet, we put our annual income. We put the bonuses, the annual bonuses, and we average those. Everything is done on an annual basis. So I think to say the year hadn't been completed, we hadn't paid the full year, any of those arguments is unfair. And I don't think Zion supports that or Wilkerson. So I think at least for our first assignment of error, I don't think there's any question that the trial court here, they should have accounted for that alimony on line 6 and 10 respectively and come up with a child support amount. Assignments 2 and 3 are somewhat consolidated together. Obviously, it's in dealing with what the alimony amount is and with dealing, or spousal support, and with dealing with the child support. All of the expenses were not taken into account. My client is a farrier, and so he obviously is self-employed, receives that money in, and his expenses obviously vary depending on whatever costs he has associated with the shoes for the horse, the rentals, the leasing, his equipment, whenever he needs to purchase it. He supplied his tax returns for purposes of the trial. Again, I was not trial counsel, but from reading the transcript, it seems that those tax returns were accepted. It does not seem...
Are you referencing the 2012 tax returns?
Yes.
So what do you mean when you say it seems that they were accepted? Are they in the record before us or not?
And yes, it is, Your Honor, and I apologize, seems was not a good word. The trial court did not find any fraud. I think the appellee was trying to demonstrate that there was some fraud element of that. To my understanding, the trial court did not find any problem whatsoever with what was reported on the tax return. What the trial court...
Well, but opposing counsel, pardon me for interrupting.
No.
Opposing counsel indicates that the tax return records were not before the court and that they were never admitted into evidence. And if that's the case, we can't consider what was not before the trial court. We're being asked to strike the reference to them. You apparently have attached them as perhaps to your brief.
Yes, Your Honor.
What I'm asking you is whether those records are actually in the record, formally in the record before us from below.
And my understanding is that the tax returns were actually admitted in the trial court, and that the trial court used the gross income amounts from those tax returns, but did not use or utilize the expense portion. And what we're alleging is that the expenses were higher, especially for 1 year, than what was given credit for when the court arrived at the income to be used for my client. I have at least cited in my brief, and again, I'm not trial counsel, so I'm always hesitant because I know I read through the trial transcript, but I certainly don't want to misrepresent anything to this court. But I have, from my brief, listed the trial transcript, page 80, lines 16 to 19, that the appellant's testimony were that his business expenses were reflected on his tax returns. It's my understanding those tax returns were submitted at that particular point in time.
So if they were submitted, then they would be part of the record.
Correct.
That was sent over from the clerk of court, or by the clerk of court.
Correct, Your Honor. I would assume that that would be the case, yes.
Did you check to see if they were in there?
I did not, Your Honor. I did not.
Okay.
And you're at your 5 minutes, but you may continue if you wish.
Just in closing, thank you, Your Honor. Just in closing, I would say that the trial, there isn't any question that the trial court had the gross numbers and the expense numbers. It's just that in the calculation itself, the trial court chose to use the gross numbers without accounting for the actual expenses he had. So certainly if you're going to use gross numbers, you need to account for those expenses when you do the worksheet. Thank you.
Good morning, Your Honors. Ms. Mills, may it please the Court, Attorney Chris Ockerly, represent the appellee in this matter, and Foy. There are three issues that the appellant brought to this court today. One, whether the trial court abuses discretion in three ways, not including the spousal support and the child support calculations, and then not taking into consideration the business expense for both the child support and spousal support. Since Ms. Mills was talking about it and discussing it, I want to go to business expenses real briefly with you, Your Honors. First of all, this hearing, if you take a look, the hearing was October of 2012. There is no way that the 2012 tax return can be part of this hearing. It's not submitted. You're not going to find it anywhere in evidence, and that's why he gave estimates in regards to the 2012, because it was in 2012. You're going to find a 2012 tax return in 2013, but this was an October 2012 hearing. That's why we're asking for 2012 tax return not be allowed.
If I may, I'm looking at the October 29, 2013 child support computation worksheet that was submitted by, well, it's a judgment entry that was submitted, I believe, by the appellant in this case, and it does show ordinary business expenses of $2,811, and that's pretty specific to be, and would that not have been based on 2012's tax return?
Well, what it appeared to me, what the court did, because it didn't have the entire figures, it estimated, it used 2009, 2010, and 2011 because it had actual figures. It had tax returns from actual figures. So if you take a look, and Mr. Foy testified at 80 on page 80 that the tax returns included his gross receipts and his business expenses, and then 3 pages later literally went piece by piece. Question: what was your gross receipts? Answer: amount. What was your gross receipts for 2010? Answer: an amount. And then asked business expenses and gave a specific business expense that corresponded to the tax return. If you take a look, his asking the judge, please use this amount for gross receipts. That's in there for 2009, 2010, 2011. He was then asked, what is your business expenses? And he gave a specific amount on pages 83, 84, and 85 of the transcript that gave specific amounts and matched the tax return. We did not have an accountant that testified at the hearing. He asked the court in testimony, please take these figures. The court did and averaged the 3 figures for the gross receipts as well as the expenses that he had those 3 years. And I think he now wants to come back, oh, I missed something, so he's bringing it up in his brief to say, look, I missed a few expenses that I should have testified about. The trial court is not required to go and analyze the tax returns to see what should or shouldn't be a business expense. She relied on his testimony and took his testimony, and then that's the number that they used, or the court used specifically. As for the 2012 tax return, again, we're asking it not to be included because it was not part of testimony. I know in the reply brief, Mr. Foy had indicated that the court reserved jurisdiction. The court reserves jurisdiction to allow for motions to modify, but not to supplement testimony at a later time when we get to the appellate level. So again, I'd ask that the 2012 tax return not be allowed. If there's modifications that are open, the trial court will deal with the 2012 at a later time. Turning to whether the child support calculation should have included the spousal support. Couple things. First of all, the court said on page 8 of its decision, page 9 of the decision at the top, that it says that the parties are going to equally share extracurricular sports expenses and unreimbursed medical expenses. And then on page 11, when discussing cash medical support, right in the middle, it says the court is equalizing household income. That is what the court did in this particular matter through its analysis. Changing the child support amount is only going to change the spousal support down the road. That's just as a matter of course what this court, what the trial court would do. But looking at Ziman dealt with a situation where support was actually paid. In fact, if you take a look at the statute, in terms of subtracting out spousal support, the statute is pretty clear in 3119.05B. The amount of pre-existing child support obligation, this is subtracting it out, and the amount of any court-ordered spousal support actually paid shall be deducted from the gross income. Actually paid. There's no testimony in here what the actual pay is. And it also says at the very last second, it's verified by supporting documents. There's not one document that was introduced to court that said that his spousal support was paid on a temporary basis. There is an order from this court, the trial court, that said he's supposed to pay temporary support. He testified he paid all of his expenses in there. He did not testify to specific spousal support payments during the pendency of the marriage, whether it was June of 2012, July of 2012, January of 2012. None of that. And didn't bring any supporting documentation at all to show that he did pay.
So are you suggesting that he has arrearages then for that period of time because he didn't pay? And is there an order out there for arrearages?
There is an order for arrearages from the spouse, from the child support calculation or computations. The child support's collecting, I believe, on both spousal support and child support, and there is an arrearage amount at this point, yes.
If he's ordered to pay spousal support, though, why do you not put it on the child support worksheet?
Again, it goes back to where the case that I cited, Albright v. Albright out of the 4th District, they took a look at it and analyzed that statute that said, look, if it was what was ordered to be paid, that would be in the statute. But the statute actually, it says, has the word that it's actually paid. The spousal support that's actually paid, and then it's verified by actual income sources. And so that's where, if you're taking a look at the specific statute, that's the difference, I think, between Ziman, because Ziman dealt with a situation where they said that amount of support was paid in that case. They had evidence that support was paid in that manner. So that's the difference between Ziman and the case at bar. I don't know if that answered your question.
To some degree, but I'm understanding that spousal support can be paid specifically to the spouse and not have to go through the agency. That may be why you're asking for specific evidence of payments being made. Whereas in this case, this was supposed to be going through child support enforcement agency.
I believe the original temporary support order had all, and I don't have that, I didn't have that in front of me, I apologize, I don't have that answer for you, but it's generally what this trial court did, but I did not see it. But on a temporary basis, usually orders a temporary child support order and a temporary spousal support order that would go through the child support enforcement agency. At the trial, that could have been introduced simply by providing the child support a calculation, child support enforcement agency worksheet to show that the amounts that were paid both in child support on a temporary basis and a spousal support on a temporary basis. Or, because he's self-employed, he would have to make direct payments to child support enforcement agency. He could show the receipts he received when he did that, or the cash checks that he paid towards that. None of that was done. There was only a very limited answer to the overall expenses he paid that says that included spousal support, but nothing specific anywhere to say what was paid and what wasn't. In it was alluded to by Ms. Mills, there's a huge arrearage in there. It's partly because amounts that haven't been paid. But we're not really, I don't know that we're here for whether he should have paid those or not. It's whether he did pay those, and whether the trial court has to include those on line 6. If you take a look at the judgment entry, the judge went right in order, went through calculation of child support, and then moved right on to the next piece to spousal support. And in between discussed that she was going to be equalizing the incomes of the parties. She certainly took into consideration the child support amount as well as the spousal support amount when coming up with those figures. And we think those figures are correct. And the reason why I bring up earlier, if this court does reverse and say you have to put the spousal support in there, the court recalculates with the spousal support in. It may lower the child support, but if she's the court is income equalizing, it's going to be a corresponding increase based on the amount that of spousal support that Ms. Foy would receive. I don't know if there's any other questions to this court at this time. We would ask that if there's no other question, I would ask that this court deny all issues in assignments of error in this particular case and hold that the trial court did what it was supposed to do in this particular matter. Thank you.
You have 5 minutes.
Thank you. Just briefly, we cited this in our reply brief, but there was evidence of the spousal support being paid in the trial transcript. It is found on page 110 and 111. In fact, it is counsel for Mrs. Foy who is doing the questioning. Just briefly, and I'm somewhat paraphrasing, and during the pendency of this case, you've been able to pay all your expenses where you're living, correct? Correct. And a $1,500 spousal support payment to Mrs. Foy, correct. So there isn't any question he was paying that through the temporary support. There isn't any question then when the court, and again, this is somewhat problematic because we've got a year between a hearing and a final decree and another year between the dismissal from this court and the ultimate final decree. So we've got modifications in all over the place where we're trying to modify based on income. Counsel makes the argument that if we do go back and we put the alimony in, the child support may be lower, but the alimony might be affected. We need to do it right. I mean, I don't think that because we say this is somewhat complicated, it means that we don't go back and we don't follow the law. I think we have to do the child support right. We don't come up with mechanisms where we just take a bunch of numbers and average some of these numbers and don't average other numbers. We need to take gross income and we need to take expenses and then we need to arrive at an income level. And
Can I stop you at that point? Because
Yes.
in your brief, I seem to recall that you spoke about the need to consider gross income expenses in order to come up with net income. And then when you get to individuals who are self-employed, I thought I understood you to say that the court may consider expenses, but was not required to do so.
I think the court can, I think you're right, Your Honor, and the court can look at all expenses, and I think what becomes the bigger argument in some of these cases is whether or not depreciation is truly an expense, and so we found a lot of that case law in drafting these briefs. I think the court can accept or reject expenses. In this particular case, there wasn't, to my understanding, a rejection necessarily of these particular expenses. It was put before the court didn't utilize those expenses. I don't see any explanation from the court that they weren't going to take certain expenses.
On the court's judgment entry on page 8, where it says that the father's income and expenses reflects the average the parties reported to the IRS, and this was, I mean, I realize this entry is dated November 2014, but it's looking back at the hearing that was on October 29th, or October 2013, which was...
Yeah, 12.
Yeah.
Yeah.
So
Yeah,
as
so
far as
yeah.
taking the specific numbers for 2013, if it's using the information that it had in It didn't have that information at that time, so that's why they took the average, is that correct?
I don't know why she averaged. I think counsel's correct that 2012 couldn't have been before the court. I'm certain, as I've now been sitting there with the transcript, that 2009, 2010, 2011 were before the court. And then there was a discussion about what the expenses would be in 2012.
And the court took an average of the prior 3 years.
They averaged those expenses, yes,
Okay.
and they averaged the income instead of, the problem that we had is we had higher expenses at the end. And I will round up, the only other thing that I will say is in our brief, we did ask that the appellee's brief be stricken. I know this court didn't rule on it, but I would just renew that. That brief was filed a week late without any request for extension. Thank you, Your Honor.
Thank you. We will take the case under advisement and send you a copy of the decision when it's issued, and you can also find it on the webpage. Thank you very much. Have a good day.